Hello and a very warm welcome to everyone attending today. My name is Philip Hoddell and I'm the chairman at Burkitt Long. I'm delighted to welcome you all to this Wednesday webinar. Burkitt Long are offering fortnightly webinars on a range of different legal subjects. In recent weeks, we've covered special educational needs in schools and construction law. Before the summer, we'll be talking about commercial rent arrears, and then we'll take a break, returning in September to look at tax and estate planning across the generations. If you're interested in any of our webinars, please sign up at www.burkittlong.co.uk/events. Today's webinar is being presented by Rianna Billington, a solicitor in our BLHR and employment team. Rianna will be giving you a general update, discussing some recent important cases, and of course, taking questions at the end. So without further ado, I will hand you over to Rianna.
Thank you very much, Philip. That's brilliant. That's it. So as Philip mentioned, I'll be taking the webinar today, and it will be a series of employment updates first. Some recent employment tribunal cases, we'll look at the outcomes and we'll look at what we can learn from them. And then we'll talk about questions, take any questions that you may have, and then that will wrap us up. So firstly, on to not the update, a little disclaimer before we proceed. So just to make everyone attending aware that the information in this presentation is for general purposes only and does not constitute legal advice, and that the information is correct as at today's date, the 29th of June, and is subject to legislative changes. So the first update that I have to bring you today is that from July, 1st of July, there are new regulations that are coming in which will allow more healthcare professionals to sign fit notes. So from the 1st of July 2022, the Social Security medical evidence regulations and the statutory sick pay medical evidence regulations will be amended to allow registered nurses, occupational therapists, pharmacists and physiotherapists to sign these statements. So these regulations will be amending existing legislation on statements of fitness for work, or fit notes as they're more colloquially known, to expand the category of people who can sign them for the purposes of SSP and Social Security claims. And these regulations will also insert a definition of healthcare professional, which will include doctors, as it always had, and the 4 new professions that I mentioned earlier. It's hoped that this change will make it easier for patients to see GPs by reducing their workloads. And obviously for HR professionals, if you're receiving sick notes or fit notes, and you do see that they're signed off by registered nurses, physiotherapists from 1st of July, that will be the correct procedure. So just something to be aware of. The second update is that the government has now committed to publishing a statutory code on fire and rehire practices, and this will be coming in summer 2020, so soon. And they've also suggested other measures will be introduced outside of an employment bill. So on the 15th of June, Lord Callanan confirmed during a parliamentary debate in the House of Lords that the draft statutory code of practice on dismissal and re-engagement, or fire and rehire as it's also known, will be published for consultation in summer 2022. Lord Callanan said that the code will set out good practice and help parties reach a negotiated agreement. And you might recall that dismissal and re-engagement practices, or fire and rehire, as they're otherwise known, received a lot of attention earlier in the year, and that was due to P&O Ferries and their sacking of 800 staff. So the government said, we're not going to legislate on this, but we do realise that we need to provide more guidance, hence why they're going to be publishing this statutory code. So that's on dismissal and re-engagement. However, also during the debate, in response to a question about the anticipated employment bill, Lord Callanan confirmed that this will be delivered when parliamentary time allows, which is something we've heard quite a lot recently. But he went on to add that there are many other ways of delivering what were manifesto commitments than a formal government employment bill. So this suggestion appears to be that the government is considering alternative options for delivering its commitments outside of the anticipated employment bill. And this is supported by the statements made by Lord Callanan. And he said that alternative vehicles for bringing forward legislation to introduce unpaid carers leave first, that was a provision that was expected to be included in an employment bill, but they're going to be considering alternative vehicles of bringing forward legislation on particular elements of the employment bill. So this is good news for many who eagerly awaited the employment bill, because there was lots in there in relation to working practices, and a lot of people were disappointed when this wasn't touched upon in the Queen's speech. So it might not come in the form of an employment bill as we were expecting, but the government are looking at other ways of bringing in what was manifesto commitments under the employment bill through alternative vehicles. What that will be is yet to be seen, but it's coming, so it's something to look out for. So that was fire and rehire practices. Next update is that ACAS has recently provided some more guidance around hybrid working. This was following a survey that they carried out, and the results of the survey was published on the 16th of June. And it showed that 60% of employers who were surveyed have seen hybrid working increase following the COVID-19 pandemic. And in addition, 52% of employers have seen an increase in staff working from home full time. And this very much accords with what we're seeing with our clients, and it may be the case for some of you watching as well. Your employers may well have moved to hybrid working models or be considering it. So to accompany these figures, ACAS has provided some further advice for employers around hybrid working, and I've just taken some bits of that to share with you today. If we could just pop to the next slide, just so we can see those, that's great, thank you. So advice that I thought was prudent to share is ACAS are really encouraging the use of hybrid working policies. These policies should explain how hybrid working can be requested and detail how job roles are assessed and how decisions will be made. A real emphasis on remote staff having the same access to opportunities such as team building, training and social activities as those in the workplace is focused on and encouraged by ACAS. And also transparency and fairness in deciding whether to approve staff requests for hybrid working or not. And also taking into account that other forms of flexible working might be considered as alternatives to hybrid working. Also a focus and encouragement from ACAS on suitable equipment being available and information to facilitate safe at-home working. That's viewed as a necessity, obviously, for employers to comply with their health and safety regulations, which do still apply when a staff member is working from home. And on the same vein, employers should also be complying or ensuring compliance with the law on working hours. Staff working at home should also still be taking adequate rest breaks and looking after their mental health. And finally, ACAS have suggested the use of trial periods to test hybrid working and to establish any necessary adjustments that might be useful. So that was ACAS and their survey on hybrid working. Another update from the government is that the Bill of Rights bill has been published. Now this is quite a controversial bill, but it has been published, so just to give you a little update on that. This was introduced on the 22nd of June, so last week, and this bill purports to repeal the Human Rights Act 1998, and its intention is to create a new domestic human rights framework around the European Convention on Human Rights and also the First Protocol and 13th Protocol, to which the UK will remain a signatory. And this bill will provide that it's unlawful for a public authority to act or fail to act in a way which is incompatible with a convention right, and also provides that a court may make a declaration of incompatibility in respect of primary or subordinate legislation that is incompatible with a convention right, and these provisions are retained from the Human Rights Act 1998. Other key provisions from the bill, it includes detailed interpretive provisions that require a court to give additional weight to certain rights or principles, and it holds that a court cannot adopt a new interpretation that requires a public authority to comply with a positive obligation to do any act. And in addition, a court may adopt an interpretation that diverges from jurisprudence of the European Court of Human Rights. The bill will also impose a higher threshold for victims of alleged breaches of convention rights in order for permission for their claim to succeed. So they'll have to prove that they've suffered a significant disadvantage to be able to bring claims for alleged breaches of convention rights. So in these and other respects, the bill constructs a distinct regime to that under the Human Rights Act, and it's unclear how it's going to operate in practice at the moment. And also it's unclear how the courts are going to react to the interpretive provisions that this new bill sets out. It's also arguable that the effects of the bill may create some friction with the UK status as a signatory to the ECHR, or even result in an increase in declarations of incompatibility. But that's just speculation at the moment, because we're unsure. You know, these results remain to be seen at the moment, and the final form of the bill actually remains to be seen. But it's likely that this subject will be discussed at future webinars as the situation evolves and as we kind of know more and as it's tested in court. But that's the Bill of Rights bill. Next update, I'm aware that I think an attendee who should be attending today, if not, I will follow up with them, asked whether we would be covering this, and it was in my updates. This is the recent change in law that the government has made. They're going to legislate to make it easier for businesses to engage temporary staff during industrial action. This was discussed on the 23rd of June, and that was last week, and you'll remember that that was a week of rail strikes, and it was also a week where other sort of unions, teaching unions, airport ground crew were also threatening to strike. So the government has announced that they will be changing the current law, and the changes to law will enable businesses to engage temporary agency staff via employment businesses during industrial action. And there will also be an increase on the cap of damages which can be awarded against a trade union by a court where industrial action is found to be unlawful. So for the largest unions, the maximum amount which can be awarded is currently £250,000, but that's going to rise to £1 million. The current position under trade union laws is that employment businesses are restricted from supplying temporary agency workers to fill duties by employees who are taking part in strikes. But the legislation announced on the 23rd of June will repeal this legal restriction, and it will give businesses impacted by strike action the freedom to tap into the service of employment businesses who can provide skilled temporary agent staff on short notice to temporarily cover essential roles for the duration of the strike. This change in law will apply across all sectors. And I'm taking MP Kwasi Kwarteng's words here. He says they're doing this, or the government's doing this, to minimise the negative and unfair impact of strikes on the British public by ensuring that businesses and services can continue operating. And subject to parliamentary approval, these changes are going to be made through a statutory instrument, and they're set to come into force over the coming weeks, and they'll apply across England, Scotland and Wales. I got the majority of my information from the government's press release, which I can share after this webinar. So at the minute, that's what's being announced. It's going to come in the coming weeks. So that's all we really know at the moment. But again, we can provide updates on that as and when we have more information. So hopefully that covers it. I know someone wanted some specific, a specific update on that, but if I haven't, ask me again in the questions and we can go back over it. So the last update that I have considers the government again. This considers the potential plans to make menopause a protected characteristic, and the government has confirmed that in fact there are no plans to do this. So at present, menopause will not be made a protected characteristic under the Equality Act. This came about by a letter to Caroline Noakes from Baroness Stedman Scott, who is the Minister for Work and Pensions, and also, interestingly, the Minister for Women. Within this letter, she confirmed that it's not actual or proposed government policy to introduce the menopause as a protected characteristic under the Equality Act 2010. And the letter went on to state that the menopause is only relevant to Part 5 of the Equality Act, covering discrimination in employment. And since the Equality Act is intended, wherever possible, to create protection across all relevant areas, the letter questions whether menopause would fit as a protected characteristic. And the letter also said that the change would require primary legislation, and at present the government has no plans to revisit the Equality Act 2010. So that might be concerning for some, but Baroness Stedman Scott did confirm that officials in the Government Equality Hub, in consultation with the Equality and Human Rights Commission and ACAS, will assess whether the existing guidance on menopause can be improved to increase employer and employee understanding of the law. And many people in employment law spheres would probably say that that is required. So in the absence of menopause being made a protected characteristic, and as I touched on, it can be an area of concern for employers and employees alike, just thought it would be useful to share some advice on what you can do at the moment with menopause, you know, not being a protected characteristic, but still potentially being, you know, discrimination claims can still potentially be brought on that basis under gender, age, and obviously gender reassignment as well. So the advice that we would give to employers is to develop and implement a menopause policy, and to really listen to the views and consult with existing employees so that you can gain an understanding of the key issues and their experiences. Also carry out risk assessment, which include consideration of staff going through the menopause, and talk about the menopause at the workplace as a workplace issue, and eliminate the kind of embarrassment and stigma that goes along with it. Sometimes people can feel embarrassed talking about it, and they shouldn't be. Also consider training your managerial staff so that they're able to have supportive conversations with staff. And also think about small things which might make a difference. So, for example, installing air conditioning or windows in the workplace, or allowing additional breaks. And perhaps go further and consider making reasonable adjustments where you can that would be beneficial for both employee and employer. So, for example, changes to the working environment, perhaps such as permitting working from home or being flexible with hours and duties. And also consider the existing guidance that does exist, that is out there and is published, which is from ACAS, on supporting staff who are going through the menopause. So whilst not everyone who goes through the menopause will be disabled for the purposes of the Equality Act, particularly as it's not going to be a protected characteristic, there will be some individuals who experience symptoms which do have a significant and negative impact on their ability to do normal day-to-day activities, and they will be protected by the Act. Employees who are treated less favourably due to menopausal symptoms could seek to claim discrimination on the basis of age, disability, gender reassignment or sex, as I mentioned earlier. So those were the updates that I wanted to bring you. I'm now going to take a look at some recent employment tribunal cases, and we're going to discuss the judgments and the outcomes and potentially the key takeaways, what we can learn from them. So next, yeah, perfect, thank you. So the first case I wanted to take a look at is the case of 3 Miles and the Royal Veterinary College. This case is about ethical veganism, and within this case, the Employment Tribunal found that a belief in ethical veganism, which included a belief in a positive obligation to break the law to expose and reduce animal suffering, did not amount to a philosophical belief under Section 10 of the Equality Act. So if we look at the law surrounding philosophical beliefs first, and you'll see it on screen, religion or belief is a protected characteristic under Section 4 of the Equality Act, and it's defined in Section 10 as follows. Religion means any religion, and a reference to religion includes a reference to a lack of religion. There was a lot of references in there. And similarly with belief, belief means any religious or philosophical belief, and a reference to belief can include a reference to a lack of a belief. So bear that in mind. That's the kind of definition as pursuant to the Equality Act. If we move on to the next slide, when the employment tribunals and courts are looking at philosophical belief and whether there is a philosophical belief, they obviously look at the definitions within Section 10 of the Equality Act, and they also apply something called the Granger test. And this was set down in the case Granger PLC and others and Nicholson. This case went to the Employment Appeal Tribunal, and the Employment Appeal Tribunal set out 5 criteria. So 5 criteria need to be met for there to be a philosophical belief. And the first criteria of the Granger test is that the belief must be genuinely held. So whilst it's not the tribunal's function to assess the validity of a belief, evidence, including some cross-examination, might be needed to establish that the belief is genuine. So that's the first limb. The second limb of the test is that it must be a belief, not just an opinion or a viewpoint based on the present state of information available. And the third limb of the test is that it must be a belief as to a weighty and substantial aspect of human life and behaviour. It must also attain a certain level of cogency, seriousness, cohesion and importance. And finally, the last limb of the Granger test is that it must be worthy of respect in a democratic society, not be incompatible with human dignity and not conflict with the fundamental rights of others. So keep that in mind as I talk through the facts of the case. Facts of the case are that Miss Free-Miles, who is the claimant, was a veterinary nurse employed by the Royal Veterinary College, who I'll just refer to as RVC. And in February 2019, she was actually arrested by police in connection with alleged burglaries by the Animal Liberation Front. Miss Free-Miles believed that animals' lives have innate value and that humans should not eat, wear, use for sport, experiment on or profit from animals, and that humans have a moral obligation to take positive action to reduce or prevent the suffering of animals, which includes trespass on private property to expose animal suffering and the removal of animals. The RVC were aware of Miss Free-Miles's views and that she was sometimes interviewed by media in connection with them, and they asked her, where RVC did not have a formal position on a topic, to ensure that they were not identifiable on any media. The Counter-Terrorism Policing Unit commenced an investigation into Miss Free-Miles's activities, and she was actually later charged and due to stand trial at the time of the Employment Tribunal hearing. They held this investigation because it was believed that she'd broken into and rescued animals, at least one animal which had been treated by colleagues and kept by Miss Free-Miles at the accommodation she was provided by RVC and where no pets were allowed. RVC also undertook their own investigation into whether she had damaged the reputation of the college and other things. And the police shared various social media accounts and posts, including a LinkedIn account that identified Miss Free-Miles as an employee of RVC, and also of animals being treated at the hospital where she worked without their consent. And one post, it was noted, was headed, "One has a moral responsibility to disobey unjust laws." Part of the investigation also uncovered, or also was carried out, because Miss Free-Miles was believed to have medication in the property which had been dispensed to a parrot that had later died, and the normal process was for that medication to be disposed of. So there were 6 allegations made in total against Miss Free-Miles as a consequence of the investigation. So they undertook the investigation, and there were 6 allegations which they wanted to discuss with her, which came from the investigation. And a disciplinary hearing was held in her absence. She'd already postponed it once, and she was advised that a second disciplinary hearing will be held and it might go ahead even if she didn't attend, which is what happened. 4 of the allegations were upheld, and 3 of which of those allegations were found to be gross misconduct. So she was subsequently summarily dismissed. And one allegation that was upheld was that there was sufficient evidence in the social media posts of the claimant's association with extreme animal rights groups and with illegal activity, such as trespass onto private property, businesses, and the associated risk of damage to the college's reputation and partnership. Miss Freemiles appealed against her dismissal, but in recognising her right to support activities and promote her own belief, they said, you know, we appreciate that you hold these beliefs. RVC rejected the appeal because they concluded that her activities had the potential to bring the profession and RVC themselves into disrepute. So upon being dismissed, Miss Freemiles brought an employment tribunal claim against RVC for, amongst other things, direct and indirect philosophical belief discrimination, and she relied, in fact, on her belief in ethical veganism, and she argued that this belief included a moral obligation to take positive action to reduce animal suffering, including trespassing on property and removing animals. The tribunal went on to state that had Miss Freemiles' belief in ethical veganism been limited to the belief that humans should not eat, wear, use for sport, experiment on or profit from animals, it would have had no reservation in concluding that it amounted to a philosophical belief under Section 10 of the Equality Act. It also said it might have reached the same conclusion had the moral obligation to take positive action to reduce or prevent animal suffering been limited to lawful action. But Miss Freemiles' belief included trespassing on private property and acting in contravention of the law, and therefore the tribunal went on to conclude that a belief to take actions that are unlawful and to interfere with the property rights of others could not be worthy of respect in a democratic society, so they did not satisfy the fifth element of the test in Granger, as I referred to earlier. The tribunal said that laws were made by democratically elected representatives, and they had to be obeyed by all citizens, and it was not open to individuals to decide which laws to obey and disobey. So Miss Freemiles' discrimination claims unsurprisingly failed. Now, there have been cases where ethical veganism has been held to be a protected philosophical belief, and this highlights, or I want to highlight, the importance of considering each set of facts individually, because it would be wrong for an individual or an employer to consider that Miss Freemiles' case concludes that ethical veganism is not a protected philosophical belief in all circumstances, because that's not true. And the case where veganism was a protected belief is the case of Casamitjana and the League Against Animal Cruel Sports, if you wanted to do a compare and contrast. So that was the facts and the outcome of the case. So what can we take away from this, and where do the workplace risks lie when it comes to philosophical beliefs? So as I touched upon, to succeed in a claim for unlawful discrimination based on philosophical beliefs, a claimant must not only satisfy all 5 of the Granger criteria, but also be able to establish a causal connection between their professed beliefs and the unfair treatment in question. If you think about it, the potential scenarios here are limitless. For example, a topical one might be that a genuinely held belief could be that COVID-19 or the COVID-19 vaccine could seriously impact a person's health, and that could arguably be capable of statutory protection, depending on if it's satisfied all 5 of the Granger criteria. So in cases where a claimant is able to demonstrate a genuinely and strongly held philosophical belief concerning an important aspect of human life and it's worthy of respect, the law will protect that individual against unlawful discrimination in the workplace in relation to various key areas of employment. And this can include areas such as pay and benefits, training and promotion, performance management, redundancy and dismissal as well. And equally, the right not to be discriminated against in the workplace is a right that arises prior to employment in the context of recruitment, where job applicants can also claim damages for unfair treatment. So it's something to be mindful of throughout the employment relationship and even before the employment relationship has really begun. It's also worth noting that another area of risk is that not only can employers be held accountable for their discriminatory conduct, but also they can be held accountable for the unlawful conduct of their employees. So that means if an employer fails to take reasonable steps to prevent bullying or harassment in the workplace, for example, verbal abuse directed at vegans or anti-vaxxers, for example, this could result in an employer having to defend a costly and time-consuming employment tribunal claim. So how can the risks of workplace discrimination be reduced? Well, discrimination in the workplace, you'll all be aware, has very serious consequences for businesses. It exposes employers to legal proceedings potentially, and it of course can also damage their reputation and employer brand. Also, more internally, it can foster a negative working environment, reduce morale and increase absenteeism, and also potentially increase staff turnover rates. So it's crucial to ensure that a workplace culture is actively inclusive and there's a community of mutual respect through policies and behaviours, and that's really the key. So a dignity at work policy is an ideal starting point when it comes to reducing the risks of workplace discrimination. And this policy should set out the stance taken by the organisation in relation to discrimination, harassment and victimisation. And it should also explain the different types of discrimination, including discrimination on the basis of philosophical belief. And in this way, staff can be made aware of what's expected of them in the workplace, and guidance can be provided on the procedure for lodging potential complaints around discriminatory conduct. Also, workplace discrimination training should be rolled out across the entire workforce, because that can be extremely beneficial. And that's because it's not only important for all members of staff to fully understand the impact and consequences of their own discriminatory conduct, but also for those responsible for making management decisions. They need to be adequately trained in these areas of risks to reduce the risk to the business. The underlying takeaway really is that the question of philosophical beliefs is a complex area of employment law, and therefore line managers and HR personnel should exercise caution when handling situations concerning beliefs that staff hold, even if these beliefs are not personally shared. And if you are unsure, it is best to seek legal advice, because sometimes doing nothing or doing something in the wrong way could exacerbate the situation. So if you are unsure, it's best to take legal advice. So that was Miss Free Miles's case. The next case I want to discuss is Burke and Turning Point, Scotland. So this is a case from the Employment Tribunal in Scotland, so not necessarily binding on other employment tribunals, but talks about whether an employee with long COVID symptoms was disabled within the meaning of Section 6 of the Equality Act. So this case hasn't gone all the way. It's not gone to a substantive hearing yet. We're just talking about the outcome from the preliminary hearing. So the preliminary issue being asked, that the tribunal was asked to determine, is whether long COVID could amount to a disability. And for many, it's quite a grey area at the moment. There has been talk that long COVID potentially could amount to a disability and the symptoms that people suffer with. So again, although not binding, because employment tribunal cases don't bind one another, it does kind of show that this is the way the tribunals are potentially thinking. So it's worth bearing in mind, and I thought it was prudent to share. So Section 6 of the Equality Act, which is on screen at the moment, sets out the definition of disability. A person has a disability if they have a physical or mental impairment, and if the impairment has a substantial and long-term effect, a long-term adverse effect on their ability to carry out their normal day-to-day activities. So that's to be borne in mind as we talk through the facts of the case. Just on to the next slide, please. Thank you. Brilliant. So facts of the case are as follows. Mr. Burke, who was the claimant, was employed by his employer Turning Point as a caretaker from April 2001. Unfortunately, in November 2020, he tested positive for COVID-19, and initially his symptoms were mild. However, after isolating, he developed severe headaches and fatigue. And he found also that after waking, showering and dressing, he had to lie down to recover and struggled standing for long periods of time. He couldn't undertake household activities such as cooking, ironing and shopping, and he experienced joint pain, a loss of appetite, a reduced ability to concentrate and difficulties sleeping. He also felt unable to socialise, and he said that the symptoms were unpredictable. He would experience improvement to only suffer from fatigue and exhaustion again. From January 2022, luckily his health did begin to improve, but sleep disruption and fatigue did continue to affect his day-to-day activities. So the claimant remained off work from November 2020 when he was initially tested positive with COVID, and later fit notes referred to the effect of long COVID and post-viral fatigue syndrome. So the GPs thought that he was suffering with long COVID, and this was evident to his employer because he was submitting fit notes, and it said in there that he had the effects of long COVID and was diagnosed with post-viral fatigue syndrome. But interestingly, 2 occupational health reports that the employer commissioned stated that Mr. Burke was fit to return to work and that the disability provisions of the Equality Act 2010 were unlikely to apply. However, relapses of his symptoms, in particular his debilitating fatigue, meant that he didn't return to work, and he was later dismissed in August 2020 because of ill health, and he brought disability discrimination claims amongst other claims. So as I said earlier, this has not yet gone to a substantive hearing, but a preliminary hearing was held because it was determined that the tribunal had to answer a preliminary issue, namely whether Mr. Burke was disabled during the relevant period for which he was bringing his discrimination claims. And it went on to conclude that he was. The reason being was that the tribunal considered that he wasn't exaggerating his symptoms and that he had a physical impairment as per the definition of disability, and that physical impairment was post-viral fatigue syndrome caused by COVID-19. They also noted that there was no incentive for him to remain off work when he'd exhausted his sick pay. That was something that the employer suggested, but he'd exhausted his sick pay, so he wasn't getting paid. And the tribunal said there was obviously no incentive left there. He was off work because he was genuinely unwell. And the tribunal was also not persuaded by the argument that his employer brought, was that the GP notes lacked particularisation. So his employer said the GP notes were very vague, and therefore Mr. Burke must be exaggerating his symptoms. The tribunal didn't agree with this, and they put that down to the severe restrictions that were in place at the time on face-to-face meetings. And they said that that didn't mean that Mr. Burke's symptoms did not exist. You know, they're putting that solely down to the restrictions that were in place at the time. So the tribunal went on to hold that the physical impairment that Mr. Burke was suffering with had an adverse effect on his ability to carry out normal day-to-day activities, and that this effect was more than minor or trivial, and it was long-term, because it could well be that it could last for a period of 12 months when viewed from the dismissal date, and that was the last alleged discriminatory act. The tribunal also noted that it was the employer's own view that there was no date when a return to work seemed likely. So, as I said, this has not gone to substantive hearing yet, so whether Mr. Burke was unfairly dismissed or discriminated against because of the protected characteristic of disability or age is yet to be decided. But this is an important case because it's one of the first, if not the first case, which considers whether long COVID symptoms, which unfortunately some people are suffering from, having contracted COVID, could be a disability. As we always say, this case should be viewed on, every case needs to be viewed on its individual circumstances. And this case doesn't mean that all individuals suffering from long COVID symptoms will be disabled, because in all but deemed disability cases, for example, cancer or HIV, they're automatically deemed disabilities. Whether an individual is disabled is entirely fact sensitive. So take it with a pinch of salt, but also it does kind of show that if the symptoms do accord with the definition of disability, and if they do have a substantial impact on an individual's day-to-day life, then they could well be disabled. So that's one takeaway. Another takeaway from this case is that it's a useful reminder that opinions by health professionals, and in this case it was occupational health, are not necessarily determinative. Employers can and should consider the situation for themselves, and they can reach their own conclusion, just as the Employment Tribunal has done in this case. So some key takeaways for employers are on the next slide, and I'll just run through those. As I've sort of said, long COVID may amount to a disability, so employers should bear this in mind in their approach to employees suffering from this condition. However, it's not a condition that is automatically deemed to meet the definition of disability, so the sequential steps in determining the question should still be followed. And also, although each case will turn on its own facts, the principles laid out in this preliminary hearing judgment would seem to apply in many cases involving long COVID, as the factual matrix of the case was not particularly unusual. And as I said, it's not a legally binding judgment on other tribunals, but it may give an indication of how employment tribunals will approach this in future cases. Also touched upon, but just to reiterate, occupational health and other medical reports are helpful in understanding an individual's diagnosis and prognosis, but they're not determinative of whether a person's condition constitutes a disability. This is a legal question to be determined by the tribunal, and as in this case, tribunals will not be beholden to the views expressed by medical professionals, and therefore opinions as to disability expressed in medical reports should be treated with caution. And finally, one thing to think about is whether reasonable adjustments may be appropriate to help employees suffering from long COVID. And that's really where this employer fell down. They obviously didn't think that there was a chance Mr. Burke was disabled, or they were willing to risk it, I suppose, and dismissed him without considering what reasonable adjustments they could have made to perhaps facilitate his return to work, if a return to work was possible. It did say he was sort of recovered or was on the mend by January 2022, so arguably it was open to the employer to try and make reasonable adjustments. But it is difficult, given the fact that we're still on a learning curve with regard to long COVID, the symptoms, and exactly how individuals can be assisted and how the symptoms can kind of be reduced, because there's such a wide variety of them. But due to this case, it is clear that long COVID is a genuine condition, and as we're learning more and more about it, we're becoming familiar with that. And employers should be sensitive to this. So keeping an open mind and engaging in dialogue with employees will be the key as we move forward and try and navigate the post-pandemic climate. So that was my last Employment Tribunal case I wanted to speak to you about. Just wanted to make everyone aware that a recording will be sent round tomorrow morning to all of you who signed up to this webinar, and within it will be a link to a survey, much like, will it be the one that's on screen, so you don't need to jot it down, it will be sent to you, and we'd really appreciate it if you could complete the survey so we can make sure our future webinars are helpful to you. It's really useful for us to be able to review. Finally, we have some, or not finally, I think I've got one more thing to say before I move on to questions. But as we said at the start, this is one in a series of Wednesday webinars. And our next webinar is on commercial rent arrears, when they're recoverable and how to enforce them. And this is taking place on the 13th of July. So if you are interested in this or any of our future webinars, then do visit our website or our Eventbrite page to sign up. Thank you. And finally, just a note on BLHR. So as I said, or as Philip introduced earlier, I'm a member of the Employment and BLHR team, and BLHR is an employment law and HR solution that we offer. So it can be quite a cost-effective way of receiving HR and employment law advice. You pay an annual fee rather than being charged on a time basis. So if you're interested, or if you want to know a little bit more about BLHR and how we can support your business, then get in contact with me or a member of the BLHR team. And you can also follow the link on the bottom of the slide there, the /chatterbox, and you can have a look at the service we offer, and do get in contact if it's something that's of interest to you. So that is BLHR. Now, if we move on to any questions, I would just encourage the lady who asked the question about the strike action and the kind of change around the law. If you're still not sure, do pop that in the Q&A and I can revisit that. But I was doing my best with the information that was provided to me. So I don't know if we have any questions. Yes, there's a few published.
Yeah, there's just one at the moment, so if there are any more, do pop them in the Q&A.
Yeah,
so the one so far is about long COVID. So do you recommend that in such circumstances we proceed on the basis that it is a disability and explore reasonable adjustments, etc.? Will this provide sufficient protection if the employee is then dismissed?
Yes, I think it's really worth taking. It's worth considering doing that. I'll say that. I'll give an example. I recently had a client come and say that they had an employee who'd been off with COVID for the week, and they asked them to stay away from work as they're entitled to do. And the employee said, I'm not testing positive anymore, but I am still feeling quite unwell, not unwell enough to not come into work, but still not 100%. So could I work reduced hours for this week? And I adopted quite a risk adverse position. And I said that, you know, she won't have a long COVID at this stage because she just had COVID last week. But if the situation did progress to long COVID, it's worth considering because of the case that recently came out, and because there is talk of long COVID potentially being a disability, to consider what I would consider the reduced hours to be a reasonable adjustment. And so I sort of took the view that if long COVID is to be a disability, and if this employee does go on to have long COVID, then considering that reasonable adjustment and making it is protecting the position essentially. So that was kind of a long roundabout way of saying, yes, I would explore reasonable adjustments, even just to kind of help with that employee sort of morale. Like I said, that employee was saying, I'm not feeling 100%, I do want to come in, and giving the benefit of the doubt and saying, okay, how can we support you, even if it doesn't transpire that long COVID becomes an issue. I think considering what the employee is saying, and if they do, they could be considered as a reasonable adjustment later down the line. So I would certainly explore what the employee is suggesting, or kind of meeting with that employee and saying, how can we assist you? Is there anything we can put into place? Should provide protection if the employee is then dismissed. And I think taking a view on whether they have long COVID, whether it could amount to a disability, is also really important as well. It will be on a case-by-case basis, but I think it's likely that long COVID we're going to see more cases, I think, involving long COVID, and it's likely, if, you know, the symptoms amount to a disability, you know, you should be kind of thinking about that now, I think. So I would explore reasonable adjustments at this stage to protect yourself should the position, you know, should it transpire that long COVID does become an issue. How are we doing for questions? I think there's another one come in.
There is. Don't be shy, people. Keep asking. So the next one is, I was of the belief that if an occupational health practitioner determines someone does not fall under the Equality Act as disabled, the employer can be reasonably expected to take this medical advice when dealing with the employee, i.e. in determining if they need to make adjustments or can dismiss without, etc. If a judgment has now been made that the occupational health was wrong and the employer is liable for disability discrimination in the long COVID case, what should an employer do in that scenario to ensure that they're dealing with appropriately and fairly with an employee with ill health when the occupational health determines they're not disabled?
Yeah, that's a really good question, and that was something I thought about too, because I know a lot of oh, it's just disappeared. It was quite a long question. I'd just like to be able to review it. There it is. That was something I thought of, because I know clients have based action on occupational health reports. So I would say that if I just go back to sort of what I said as the key takeaway, that the real thing to do is just to take it into consideration, but try as best you can to also kind of formulate your own opinion by comparing it potentially to the definition of disability, and almost putting yourself in, if this did go to tribunal, would it be likely that an employment tribunal would find this employee disabled? And obviously that might require requesting GP records, which you are able to do with employee consent, to kind of take a view and see if there's any more evidence in there that might kind of change the position. But I think occupational health is a great resource, and whenever there is absence management issues, occupational health should be sought, advice should be sought, but I suppose just don't kind of place absolute reliance on an occupational health report. Normally, I think they'd couch it, say this employee on their symptoms may sort of will, or may, rather than using will, may constitute a disability under the Equality Act. So I think it's just not sort of placing all your eggs in one basket, relying completely on an occupational health report, and kind of trying to make your own formulate your own opinion and judgment. But essentially the only real opinion that matters is if it went to employment tribunal, and the tribunal obviously makes the determination as to whether the employer is disabled or not. So I think still exercise caution. If occupational health is saying that they think the employee might constitute as disabled under the Equality Act, then obviously follow advice and make the reasonable adjustments. If they're saying they're not, and you're a bit concerned about that, then I would still kind of go ahead and make reasonable adjustments. But it does kind of throw it a little bit into question, but I suppose it's always best to just not act in complete reliance on what occupational health is saying. So gather other medical evidence. If you're still unsure, you can also ask for GPs to provide an opinion, or specialists to provide an opinion. If you need to make determinative action, determinative action on whether an employee is to be dismissed or not, I would say that exercise caution, don't act in complete reliance on occupational health reports. I think that's what this case kind of shows. I think there's another one coming.
Yeah, thank you, Rianna. Emma asks, we have an employee who has been diagnosed with a condition, potentially long term, which her GP states has been caused by the COVID vaccine. We are a care company who mandated our employees to have the vaccine. Are there any cases which are being reviewed through the courts where this is the case?
Yeah, that is, I don't think there are any cases at the moment through the courts, because I think depending on the law at the time where you were mandating your employees, I assume you were mandating your employees to have the vaccination when that became a legal requirement, and the law protected any pushback. It was obviously you were able, hang on, so wait, that because the employee's not been dismissed, have they? So GP states with who mandated. Yeah, I think at the time you had kind of, there was almost protection from any pushback when mandation was a legal requirement. So obviously the government said all care home workers have to have a COVID-19 vaccination, and they couldn't obviously claim unfair dismissal or other things. I wonder whether there was anything in, when anything was signed to kind of say if you have adverse effects from getting the COVID vaccine, that might assist you, but there's nothing, any cases being brought in the employment tribunal specifically, because that would only deal with unfair dismissal, and unfair dismissal was not an issue at the time that was being mandated. you can't, you were able to dismiss employees who weren't vaccinated. So I'm not aware of any in relation to being caused by any issues being caused by the COVID-19 vaccine. But I suppose the issue for you will be if the employee could be determined disabled, then you should be making reasonable adjustments. I suppose that might be a personal injury thing, which is not really my area. But if the issue is that the employee is potentially disabled, then obviously look to make reasonable adjustments and support them where you can. But I can have a look. But as I said, I think that'd be more a personal injury issue. I certainly know that there's no dismissal cases being brought because at the time you were able to dismiss if your employee was refusing to take the COVID vaccine. So yeah, if you leave me your email, I can have a little look, but unfortunately it's not my remit, the personal injury kind of element.
Thank you. Another one, if occupational health suggests employee is not fit to work without a time frame and suggests the employee refers to a doctor for meds and sign off, fit note not received, is SSP still due as a medical practitioner is suggesting not fit to work but not signed off a fit note? And there's another note here saying the occupational health suggests it would be a disability under the Equality Act.
Okay, so if they suggest an employee is not fit to work, suggest employee refers to a doctor for meds and sign off. Okay, so I suppose if they're not fit to work and they're unwell, but there's no fit note, you would need to look at the requirements of SSP and the entitlement to see whether SSP would be payable. So I'm just, as I said, it's quite, I can't pull them off the top of my head, so I'm just having a little look. But usually SSP, if you've been ill for 4 days in a row, there's certain other qualifications, but if you've been ill for 4 days in a row, including non-working days, then SSP may be payable. Obviously, if you've been off for more than 7 days in a row, you must give your employer a fit note. So I think SSP would be payable, but you would need to see a sick note if the employee's been off for 7 or more days, which it sounds like they probably are. Refers to dogs and sign off, fit note not received. Medical practitioner suggesting not fit for work but not signed off. Yeah, so obviously the entitlement begins after four days, including non-working days, but if it's been 7 or more days in a row, you can request a fit note. So I think you would need to see that for SSP to be payable. But obviously check any company sick pay policy you may have, be it contractual or be it non-contractual, because there may be an entitlement to company sick pay. Just check a contract or any staff handbook to check you're not falling foul of if you're not paying anything at the moment.
Thank you. Just had another one sneak in. So would occupational health recommending the employees off not be medical suspension? I think it's up. Would
occupational health recommending the employee is off not be medical success? If that's something in staff handbook, then yeah, potentially I would look and see if you're able to suspend on grounds of medical issues, if that's in a contract or staff handbook, then it could well be. But I think the question was more for the purpose of the SSP. So I would just advise you to have a look at the eligibility to SSP, and if you require a fit note because it's been 7 days or more, then try and obtain that from the employee. Yeah, I think that's. I'm not sure if that was from the same person. I don't think it was, but hopefully that covers it.
I think that's all the questions. Thank you, Rianna.
Perfect. All right, brilliant. Thank you very much, everyone. If you want to get in touch with me, then you're more than welcome to do so. My email is there and my telephone number. Drop me an email if I wasn't clear or anything, you just want a clarification on further things, then I'd be more than happy to assist. But otherwise, I'll let you all get on with your evenings, and thank you very much for attending. I think I've just seen one in, will the slides be shared? I'm happy for the slides to be shared if that's something we can facilitate. I think it is, so we'll send those along with the survey link. All right, thanks very much, everyone.